Hey, good morning to everyone. An introduction to law. I'm going to go over chapter three, which is legislation. Quick summary. I think the book does a pretty good job on explaining what legislation is and how does legislation work and the purposes behind legislation. And I feel obligated to put up a little bit of essential review that I think hits the sweet spots, if you will. The book starts off with the legislative branch. One thing the book doesn't talk about, and I think we have been often educated to believe, we have three co-equal branches of government, one of them being the legislature. If you look at the federal constitution, it starts off with, well, after the preamble, there's three main articles describing the branches. The first article is Article 1, thus the first article, and that's the legislative branch. And then Article 2 is the executive, the president. Article 3 is the judiciary. What's fascinating is I think we've often been told, and I've been told many times, and I often read that we have three co-equal branches of government. It's not the intent of the framers. The framers intended the legislative body to be the most reflective and most powerful branch of government at the inception of our nation. There's no question about it that they did. And they wanted to put in a lot of prophylactic protections to make sure that no group of individuals became too powerful and no group had enough power to make minority interests, those that were unpopular or in the smaller groups of interest, to be able to be taken advantage of or squelched in their terms of the participation in society. So they put in a bunch of checks and balances, if you will. But this chapter is about the legislature, which the framers thought would be the most important. Why? Because the legislature creates laws, and we know laws have the power to create tyranny, potentially. Also, they have the potential to create a balanced and hopefully fair society. And it's a delicate balance, making sure that special interests of the few don't outweigh necessarily the interests and goals of the many, while still protecting those that are on the outliers, that aren't as part of the majority. It's not just about helping the majority, it's about helping society as a whole. So we have to create this very delicate balance in how we create law. But anyways, that's the legislative branch. The federal does mirror most states in many respects. There have to be a Republican form of government, meaning that it has to be representative of the people through elected members of the legislature. How that legislature is structured can be different in each state, but Massachusetts is very similar to the federal. In fact, Massachusetts Constitution predates the federal Constitution for about 10 years, and I would argue that the federal Constitution used some of the structures in the state of Massachusetts system as a modeling tool. The difference in the state of Massachusetts versus the federal government is, in the state of Massachusetts, our state senators, although representing a larger geographical area and therefore more people, only serve a 2-year term in Massachusetts. The Massachusetts state senators only serve a 2-year term, but there's less state senators than there are House of Representative members. They represent more people in a broader geographical area, but they serve the same 2-year term as the House of Representatives do in our state legislative system. But they create law in Massachusetts. On the federal level, we know the House of Representatives and we have the United States Senate. How are they made up? Where do they come from? Well, for purposes of testing, an important sort of set of standards you want to know is, well, who's eligible to be in these branches? Well, we have in the House of Representatives 435 members, and they are dispersed based upon geographical representation for each state. So every 10 years, we do something called the decennial census, and we determine where people are residing. And so based upon the population, each state will be given a certain amount of membership in the House of Representatives. About, 6-7 years ago, Massachusetts actually lost one because our state either lost population or didn't grow as rapidly as other states probably. I don't know what states are growing right now. Florida, Texas, I don't know. They could be losing. I'm just giving you an example that whatever states grew, they may have gotten a new member eligibility into the House of Correction. Some people, that's things where they belong. Into the House of Representatives. Massachusetts lost one, and so we had to merge some districts. John Oliver, who I think was out of Amherst, actually retired. The timing is perfect, and it's not his specific seat. They had to redraw the district maps, and the timing was sort of perfect for his retirement because if he didn't retire, there was a real question, would he be pitted against Virginia Hill out of Springfield because of the population shifts in our state becoming diminished, and we lost a House of Representative members. I said, well, is that really a big deal? Well, yeah, because the more members that your state has in the Congress, arguably the more likely you'll be able to get legislation passed that might benefit your state. And everyone thinks, well, don't all Congress members work for the benefit of the country? Well, of course, I hope, but they also work for the benefit of the people they represent directly in the districts they represent. And so there's that tension there. So if you are in a state like California, which has a significant number of members in the House of Representatives, you'd think that they would work in conjunction with each other to bring home the bacon to California. And just like we would think our members in the House of Representatives from Massachusetts would fight to bring projects and monies and benefits to the state of Massachusetts. So I don't know what we have right now in Massachusetts, 10 perhaps House of Representative members. I don't have it memorized. And for them to be eligible to run to become a member of the House of Representatives, you should know that they need to be a citizen of the United States for 7 years. They have to be 25 years old. And other than that, there's no strict requirements. Sometimes the states participate in creating residency requirements. You might have to live in that district for a period of time, but usually it's fairly de minimis. It's just a requirement that you have the intent to reside there. In fact, when people run for the United States Senate, they sometimes see an opportunity because they're extremely popular in a national perspective, and they might move to another state to run for Senate, seeing a vacuum or a potential victory there. Hillary Clinton did that when she ran for U.S. Senate from New York. She wasn't residing in New York at the time she decided to run. She moved there and became eligible by living there for a very short period of time and won the U.S. Senate seat out of New York. Robert Kennedy did the same thing in 1964. He moved to New York and ran for Senate after living here for a very brief period of time. But other than that, they have to be what? 25 years of age, have to be a United States citizen for 7 years, and they're eligible to run for the House of Representatives seat. The Senate's different. Now, why do we have a Senate? Well, the framers thought part of an inherent check on the legislature was creating bicameralism, two different bodies that would have potentially different perspectives about what the best interests of the states and the society in America would be. And by creating that tension, we would think that the two branches, in order for a law to be passed, would have to come to an agreement. By having that inherent check, hopefully the debate and the give and take between the Senate and the House, which would, at the time, would be made up of different types of characters that would be representative of the population, would create a tension such that laws that came out of that body might be a little bit more wise, and the process would be slowed down enough so the heat of passion wouldn't dictate how a law would be passed. Well, in the Senate, we know part of the framers' desire to create a national constitution and a national government was we had to bring in large states and small states. How do we appease the large states? Well, large states with large populations would get more members in the House of Representatives. In fact, southern states were so upset over losing potential power to a national government, they wanted the census to actually include African American slaves as part of the head count for determining how many House seats they'd get. And we know one of the big compromises that came out of the Constitutional Convention of 1787 was the northern states didn't think it was appropriate for slaves to be counted as citizens. The southern states did, so the Great Compromise was called the Three-Fifths Compromise. Slaves would be counted as 3/5. So for every 5 slaves, they would count as 3 persons of citizenry in the Georgia, South Carolina, wherever it was, therefore increasing their representation in the House of Representatives. That no longer exists. That's been nullified by later amendments, of course. But everyone is counted that are citizens of the United States, including even then, back in the early creation of our country, African, even though they didn't get to participate, had no civil rights and were enslaved in a horrific period of our historical lineage, but they counted as 3/5 under that Great Compromise. But the other compromise that I'm speaking of, or was trying to allude to initially, is, well, large states would be happy with the House of Representatives. They get much more representation and therefore much more power in the early inception of our country. States like Virginia, Pennsylvania, Massachusetts would be very, very happy. The small, tiny states like Delaware and Rhode Island and New Jersey at the time would be very, very unhappy. And they would say, why would we give up our power to a national government that's going to be really controlled by New York, Pennsylvania, Virginia, and Massachusetts We just assume stay, autonomous as autonomous powered states, independent country, really. And so the compromise there was sometimes called the Sherman Compromise or the Connecticut Compromise, because that's where Sherman came from, proposed, well, we're going to create this bicameral legislative body that we're going to reward the large states with more House of Representative members, but to make it somewhat more equitable, not equal, but equitable, the Senate, every state, just by being in existence as a state, would get 2 senators. Now, some states have very small population, only have 1 member of the House of Representatives because of population, but they have 2 senators. I believe Rhode Island has that situation, and I'm pretty sure either Wyoming or Montana also have the situation because their population is so small. They only get 1 member in the House of Representatives, but 2 in the Senate. In the early inception of our country, part of the check on democracy and mob rule and overzealousness and popular sentiment was the Senate was not elected by the people directly. The Senate was actually, up until 1913, our United States Senate was selected by state legislatures. And there they thought there was a buffer. The state legislature would know who the best and brightest were within a community, who had the appropriate temperament and skills and hopefully a meritocracy that they would merit actually representing that state in the Senate. But we became more democratized over time, and we recognized that we wanted the people to directly pick their U.S. senators. So there's an argument that the characteristic of a U.S. senator is much more akin now to a member of the House of Representatives. They're not as distinctive. At one time, the Senate was thought of as more as an aristocratic body of the wealthy and educated, where the House of Representatives was more representative of the common person. I don't think that distinction is necessarily true today. But the bicameralism does slow down legislative process, because if a bill, a proposal for a law starts in because any law can start as a proposal, we call that a bill. It can start in either the Senate or in the House of Representatives, with one major exception. Any bill that has a tax revenue component to it, which is many, has to start in the House of Representatives, because we want taxation to be most reflective of the people. And back in the early days, like I said, the Senate wasn't elected directly by the people. So if it was going to be revenue expenditures or revenue raving taxes, it has to start in the House. Doesn't mean the Senate has to go along. Doesn't mean the Senate can't have ideas about how a revenue generating bill should be proposed. So they often work hand in hand, but it has to technically start in the House of Representatives. It's more of a Trivial Pursuit question. But in either event, a bill can start in either branch of our bicameral Congress. And I might actually put up the video of I'm Just a Bill. It was a thing called Schoolhouse Rock. It's pretty, it's shockingly accurate about how a bill will start this process. Either a group of citizens will petition their House of Representative members or the U.S. Senator. We think we need a law in this area to do something. It becomes a proposal. It doesn't just go to the House to get voted on, then to the Senate to get voted on, or vice versa. Start at the Senate, get voted on, then go to the House. It goes to committee initially. So it gets proposed, and they say this topic relates to, I don't know, it relates to something to do with expanding a new court in federal realms to deal with admiralty law. So they would give it to the Committee on the Judiciary. In that committee, I don't know how many people make up it, but a certain committee in the House of Representatives will have, 15, 20 members, and the same in the Senate will have maybe, 7 or 8 members. They'll hold hearings on that proposed bill to decide, is it needed? Let's hope they don't just create laws just because it's fun to create laws. Let's hope they create laws because there's a necessity to it. And they'll have hearings, and they'll bring in lobbyists. And a lot of people say, well, I don't like that. I'll get to that in a second. Well, I'll get to that right now. They bring in lobbyists and interest groups that have a stake in that bill, because those are usually the ones that know what the outcome will be, both positively for their interest and negatively for their interest. And so a lot of information can be garnered from special interest groups and lobbyists, because they're the ones that are experts in the field. Think about it. If I'm Boeing, I work for Boeing Aircraft, and there's new aviation laws that are potentially being proposed, and say I'm a lawyer and I get hired by Boeing to go to one of these select committees to hear about this potential bill, I can say what's good about the bill and what's bad about the bill, how it will hurt Boeing, how it would hurt or benefit the aircraft industry. And it carries some weight with these committees. But the committees can bring in all kinds of different people and summons them in to give testimony to determine the validity of the bill, what changes should be made in the proposal, because they can work on it in committee and they can come out with a very different proposal that first started there. But if it gets approved at the committee level, then it goes to the full branch, the full House of Representatives, or the full Senate to be voted on. If it passes there, then it goes to the other branch, goes through their committee, and they can make amendments and modifications. Then they vote it. Now what do we have? We have two different bills supposedly about the same topic that are slightly different or maybe significantly different. And now they work on a joint committees work on refining and making one bill that's consistent between both the House and the Senate. They re-vote on it. It's a long, usually slow process, unless it's really a national emergency where there's consensus on what needs to be passed. Laws, there's an old saying, I always hated the saying, but I guess I hate it because it makes a lot of sense in some ways. Watching and knowing how laws are passed are like watching and knowing how sausages is passed. You might enjoy the outcome, but the process when you watch it is kind of disgusting and frustrating and difficult. And there's no question about it. Bills can die in committee. Sometimes that just recently happened here in Massachusetts. There was a bill, I can't remember what it was about, and it seemed like there was some excitement about it getting passed. And that's what it was. It was expanding the judiciary's ability to hold people on dangerousness. Right now, when somebody's charged with a crime, they have to set reasonable bail. But there are some exceptions where a person can be held without bail because they're deemed dangerous, but there's only certain statutes that apply to that. Governor Baker wanted to expand it. He proposed it to the legislature. It went in the legislature. It was getting bantered about, debated. And then someone says, we need to send this off to study. Often what that means is when something's sent off to study, it disappears, often like some of my socks seem to disappear during the laundry, and they're never to be found again. Bills can languish for decades. People say, oh, it can't. Yes, it can. I'll give you an example. For example, I've worked for the state as a professor here at the Mount for almost 20 years now. And when you work full time for a government entity that has a retirement pension plan, there's an offset, meaning that if I paid in my quarters and worked in private industry, I can't get my full benefits of security because I'm going to get a state pension. It's to prevent a windfall, I guess. Well, that's become unpopular with people like me who would like to get my full Social Security retirement and my state pension. I paid into both. Why can't I get both is the argument. So when I first started at the Mount in 2002, 2003, people would talk at the union meetings like, well, there's this law being proposed. That was back when John Kerry was our U.S. Senator from Massachusetts, and he would supposedly talk through his staff about, yeah, the bill's at this stage going here. The bill's still there. It's not dead technically, but might as well treat it as dead because no one's talking about it actively. And it went off to study to see what the economic ramifications are for the nation, tax-wise, all these other things. It's dead. So my point is, just because there's a process doesn't mean bills can't fall through. I would think of it like a grater with all the holes in it. As the bill's going across that, it can fall through those holes and die a natural or unnatural death along the way. And sometimes through the amendment process, bills who started looking like XYZ come out looking like ABC, and it's very different, watered down, or fundamentally inconsistent with what the desire of the original proposal was. So, anyways, that's the kind of the process. To be a senator, again, the Senate was supposed to be people who are, initially, the framers were hoping they would be probably wealthier, more landed, more educated, more of the upper crust of society. There's no question about it. And I guess might as well meet one of my dogs sitting behind me. That's Bailey, Golden Doodle. You can see it on the corner. I see her looking at me. Now I lost my train of thought. So the Senate, because we wanted to be a more mature, aristocratic body, the Constitution mandated that in order to be a senator, you had to be at least 30 years old and be a United States citizen for 9 years. Well, again, remember when the framers were making the Constitution, being 25 for the House of Representatives was a much older age than I think of 25 is today, and same with 30 in the U.S. Senate. The life expectancy was much different during that era. But those are the basic criteria. Make sure I'm not missing any rules for them to be voted in. 7 years. In the term. To House of Representatives every 2 years. There were people that didn't like that, wanted to reject the Constitution because that's too long to let a person in power stay in power that long. We were fearful of power being concentrated for too long in any individual or group of individuals' hands. And so many people wanted the House of Representatives only serve 1 year. Well, part of the compromise is give them some time to study legislation and get things done, and we wanted legislation to be slow, so they serve a 2-year term. Senators, because they were going to be appointed by the state governments, the state legislatures, we wanted them to be a more stable branch of government. They were given 6-year terms, which was outrageous to many anti-federalists. Thought that was way too long to allow them to sit in office. Well, we know there's another issue now that once you're elected to office, unless you're really a scoundrel, you tend to stay in office as long as you want, or strive to stay in office, because it's very difficult to unseat incumbents. It's just a very different process, and that's why there's calls for term limits. And the only term limit we have right now built in our Constitution is for the president, and that didn't exist at the early inception of the Constitution either. That came much later through constitutional amendments because of FDR being elected for consecutive president over 60, arguably could serve 60, died very early in his 4th term. But senators serve for 6 years in order to create even greater stability. On the 6th year, not all 100 senators, each state has 2, we have 50 states, not all 100 senators are up for election. They staggered the initial inception of our government, meaning the very first Congress, some senators would serve 2 years on the first go around, some would serve, another 1/3 of the Senate would serve 4 years, and the last third would get the 6-year term right at the inception of a nation. But then upon the next election, you'd get the 6 years. That way we create a staggered Senate, so that way every 2 years, only 1/3 of the Senate is up for election. That creates some stability. We can't throw the entire government in terms of that tier of the government, the Senate. We can't throw them all out in one election cycle. It takes 3 election cycles, 3 2-year processes to go out if we want to throw them all out, slowing down sort of the electoral revolution, if there was to be ever one, and there hasn't been. So they pass laws. Now, the purpose of legislation, the book does a nice job in it. I'm not going to get into it too big. Well, one is protective. This is to protect our liberty against obviously government interference, but also protect our liberty against really interference by other citizens, to create a framework to create a peaceful society on which our freedom and autonomy to succeed and become self-actualized and be happy and all that kind of stuff is protected. So many law, big group of laws, is designed to be what we call protective. I'm not too keen on a test on that. The other one is remedial, and that's things like correcting things that were wrong. We give an example. The 13th Amendment, which ended slavery, is a remedial statute. It's correcting a societal wrong that occurs. Workers' comp is another one. You're injured at work, you're out of work, you don't have pay coming in. The remedial statute allows you to seek compensation so people can be both protective and remedial. It's trying to redress a wrong. Environmental laws are often thought of as remedial, hopefully clean up water, clean up the air, things like that. The third one is procedural, which we'll spend a lot of time on in later chapters, and that's in order for people to protect their rights, protect their interests, protect their property. You have to have a process. If I feel like my property rights are being infringed upon, or my civil liberties are being infringed upon, or being fundamentally treated unfair by a neighbor or a government, I should have a process of redress, a method in order to be heard in most circumstances. And that's called procedural law. Procedural due process means fundamentally fair procedures to seek and redress, to seek rights, and to have protections of those laws enforced appropriately. Those are the 3 fundamental purposes the book does. It's kind of obvious what laws are for, right? The purposes behind them. The process I already talked about when a bill first starts off. Bill is not a law. It gets proposed by, again, either the House of Representatives, some member. It can be everyday citizen can petition. And let's face it, if you get enough people together and you tell your U.S. congressperson that, we've got this issue, we think this change needs to be done, they'll take it up, because if they have to get elected every 2 years if you're in the House of Representatives. Even in the Senate, there's fear that if you're not responsive to your constituencies, at least giving them, some kind of credence that they exist and their concerns are legitimate, they might be tossed out of office. That's the political process we have. But the bill technically there is in state law a thing called a referendum and initiative, where if our state legislators are ignoring us, we can do it through that mechanism. The marijuana laws in Massachusetts are a perfect example. The legislature didn't want to do anything about legalizing both medical marijuana, but even more importantly, they didn't want to touch recreational marijuana with a 10-foot pole. And so we had to bypass our legislative process through initiative and referendum. In the federal government, we don't really have that. we have to get a member of the House or a member of the Senate to sponsor the bill. So it goes through the process, which I already talked about previously. Let's assume the House and the Senate finally say, yep, we want this new law. It's going to require this. All cars will be electric in the nation by a certain date. All new cars, something like that. Let's hope we don't get all, well, I should say we hope. Maybe we should hope we don't get. I just have a car I kind of like. I want to drive it. It's a combustion engine. It's not a law yet because we have checks and balances. And what's the check? It's the U.S. president. Now, there's two different ways in which they can veto the law. Like, so say that the legislation gets passed by the House and the Senate. There's a proposed law. Maybe there's excitement over it. Maybe there's not. Maybe a lot of people in the society are saying, I can't believe the legislature just proposed this crazy law. The president might think the same way and say, I think this law is terrible. And if they really have strong political views about it, they might do an overt veto. They might make it perfectly clear their intentions about why they're vetoing the law. They might even make a veto statement saying why they are basically shooting down the proposed bill. That's a political statement and it's very strong. Now, the checks and balances against a president that might be out of control or might not be in touch with what the will of the people are is to override a presidential veto. So President Corman vetoes this proposed legislation. He thinks it's going to raise way too much tax burden on the American people. So I'm vetoing it. Well, the Senate and the House can go back and take it up. And if they get 2/3 of the House and 2/3 of the Senate, no easy process. And that's what the framers wanted. They didn't want lawmaking to be easy. If you can get 2/3 of the House and 2/3 of the Senate to override the presidential veto, it becomes law. That's very similar to our own state constitution here in Massachusetts, that if Governor Baker, who's, well, for a short period of time, he's still the governor. I might show this video again next year. It's going to be another governor. But whoever the governor is in Massachusetts, the legislature can override the governor's veto by 2/3 majority of both the House and the Senate. And sometimes they test ahead of time. It's not like it's not really rocket science. They pass a bill going to the president, and if they know it's kind of just passed by mere majorities, it's a close call just getting through the legislature, and we know the president's going to veto it, we know that's probably a dead duck, and they won't even try to bring up an override of the presidential veto. But other times we know there's strong, what we call bipartisan support of the bill, and for whatever reason the president vetoes it, it can be overridden again by 2/3 of both the House and the Senate. Now, the president has a couple of methods by which they can either approve or veto a bill. One is if the legislature is open, just to be clear, if Congress is not in session, they're in recess. It's given to the president. The president has 10 days to either sign or veto or do nothing. If they do nothing and Congress is in session, that's called a pocket veto. Okay, so let me read it to you specifically. If Congress is not in session, they're on vacation, there's only periods of time during the year they're in session. If they're not in session, the bill has been sent to the president in almost 10 business days. It counts Saturdays, just doesn't count Sundays. 10 days goes beyond, not counting Sundays. It's a pocket veto. They're not in session. Why would the president do a pocket veto? Why wouldn't he or she just come out and say, I'm rejecting this law. This is terrible. Because sometimes they don't want the political ramifications from that. They want the bill to sort of just die on the vine, and that's called a pocket veto. I guess they're somewhat rare. The other is the overt veto. Then there's the other method where the president's not really enthusiastic about this law. He doesn't think, or she doesn't think, there's a lot of political benefit from passing the law. If the Congress is in session and the president doesn't act within 10 days, it's deemed valid. It's deemed almost like an implicit approval. I guess it's kind of nice to know the process by which vetoes and non-veto methods of approval of a law takes place. So pocket veto, Congress is in session, but the president doesn't act within 10 days. That's considered a veto. The law is not in effect, and the Congress has to override it with 2/3 of both the House and the Senate. If it's not in session, or if it is in session, and the president doesn't act within 10 days, the president implicitly consents to it, and it's now the law of the land. Now, is there another check on it? And this gets to actually a later part of the chapter, but I can jump around. I guess there's no crime against me jumping around. If the law goes into effect and someone challenges it, many people think we can challenge it. I hate this law. This is really a stupid law. It's insane, and all the kind of things that people argue about when laws get passed. That doesn't give you a right to bring it to the court to challenge it because of stupidity because it's expensive, because it hurts your business. The challenge is only one, and it's very narrow. It's unconstitutional. We know from Marbury versus Madison, a very famous case, which we'll go over in a later chapter in Judicial Review, the Supreme Court of the United States said that the judicial branch's check in its power is derived from being able to interpret law and being the final arbiter of the law's meaning, including the Constitution. So if they find that the Constitution requires or mandates or rejects certain behaviors and certain laws, and if the legislature or the president tries to act in a certain way inconsistent with those limitations, the court can strike it down as unconstitutional. Therefore, the law is void and invalid. I'll give you an example back. Some of you might remember the case of Terri Schiavo. Terri Schiavo was a woman who was on life support down in Florida, and her husband went through the Florida courts to determine whether or not he could decide not to have any more medical procedures to keep her alive, basically take her off life support. And it became a national sensation across the country. Keep her on life support. Don't let her get pulled. The parents wanted her to stay on life support, but the courts in Florida determined the husband had the final say in this question. Well, it went through the federal courts for some reason, and finally the legislature, in emergency session, the House and the Senate got together. This was when George Bush, I think the younger, was president. And they passed a law keeping Terri Schiavo on life support, and the president, George Bush, signed it. It became law. Well, somebody challenged it and said, Congress, it's not about whether the law is moral or good or ethical or does a just thing. It's whether or not it's constitutional, meaning under Article 1, Section 8, does the Congress have the power to create such a law in this area? Is it about taxation? Is it about commerce? Is it about coining of monies? Is it about raising an army and a navy? The things that the Congress has specific powers over that are enumerated powers, or is it something that relates to them under the reasonable necessary clause? And the Supreme Court says, no matter how righteous this law is, it's not within the realm of Congress to pass such a law, and therefore it's null and void. And that does happen from time to time. That's the history of the checks and balances. The book jumps to constitutional amendments. Why do we need to know that? It's just like any other law. There's a law out there that needs to be tweaked or fixed. We often call it basically a repealing of the old law and a new statute supplements it. But on the constitutional level, we don't reject the entire Constitution. We amend it. And you should know the amendment process for the Constitution. The only method that we've ever used in the past is that a constitutional amendment proposal gets proposed by 2/3 of the House and 2/3 of the Senate. If 2/3 of the House and 2/3 of the Senate agree we need this new constitutional amendment, then it gets sent to the states where the people will vote on whether or not to approve the proposed amendment that came from Congress. So 2/3 of the House, 2/3 of the Senate, 3/4 of the states. That's 38 states. Very difficult to do. If you think about the first 10 amendments kind of coming with the Constitution, right? The Bill of Rights came within the very first Congress. We've only amended it another 17 times. There's 27 amendments to the United States Constitution. Very difficult to amend the Constitution. The nation as a whole really has to have a lot of momentum and a lot of strong majority determination to do so. In fact, the Equal Rights Amendment's been bantered about since the 1970s, and it's come up again here in the 2020s. Because now they think they have 30 states to pass it. Well, some of the states that pass it now saying, well, when we passed it 20 years ago, we now have a change of heart, and our vote doesn't just hang out in the wind and is valid. So that's one of the nebulous parts of the amendment Constitution. When an amendment's proposed, how long does this proposed amendment get to stay alive? And there's no clarity under the United States Constitution of how long a proposed amendment can stay alive. But that's the amendment process. We don't amend the Constitution very much. Big things, prohibition and the repealing of prohibition. Those are some of the amendments. But some really big ones like the 13th Amendment, ending slavery, is a critical amendment after the first 10. Granting the right to women to vote in 1919, 1920. The 19th Amendment to the United States Constitution, very critical. I would argue 1973. On federal elections, lowering the age of voting to 18 because we're in the midst of the Vietnam War, and many of the people serving in Vietnam and dying and taking on that challenge were between the ages of 18 and 21 and couldn't even pick their legislators on the federal level that were sending them off to war. So that was an amendment that was done in the 1970s. Some of the other amendments are much more obscure, but that doesn't mean they're not important because they would never get the headway to be passed. But then they talk about the function of lobbyists, and I think I already alluded to that. Lobbyists and special interest groups really have a dirty connotation. I mean, if I was running for office, which I've often thought of, you look and you say, well, my opponent works with lobbyists and special interest groups. I work for the people. I mean, that sounds like a good slogan. But the reality is lobbyists and interest groups often bring us the salient and important information that relates to laws that we potentially pass. They're really necessary in our democracy in order to bring about information. Like, if I'm really into animal rights, so I want to pass a law that, cows and chickens have to be caged in a certain way in order to be humane. I might think that's a really great law, but I didn't talk to any of the farmers out there. And do you think farmers and dairy farmers and chicken, egg farmers, poultry have an interest in what that law might do? It might bankrupt them. It might take the poultry industry and put them out of business, or it might make the cost of chicken go up, tenfold. We might want to consider what we're actually proposing by hearing from those lobbyists and special interest groups that come along. We know they have a selfish interest, but they also may have valid information for us to consider. And usually try to invite all the, PETA, I'm saying if it's animal rights, you want to, all sides you should, because that's why you have a balanced and fair, hopefully, outcome with a proposed law. Public hearings and sessions, and that's what public is important, same with trials. We don't want this stuff hidden from the world. The only things that ever should be private are things dealing with national security, so that our interests aren't revealed to the world in order to compromise our safety and security. But everything else should be out in the open, so we can see when a senator looks like they're, or a Congress member, a House of Representative member looks like they're disinterested or didn't show up to the hearing, or is being a jerk or whatever. I mean, that's being in the public's very, very important. And those hearings are public, and those session laws later become law. If you ever hear a title, you hear things like Title 42, USC 18, that is where you find the book. And literally, it'd be title, and there's several laws under Title 18. It's a big grouping of laws. And then when you hear USC, that stands for United States Code. You know you're dealing with federal statute when you hear USC. And then it'll have a section because everything's broken down. It'll have a subsection. And over time, you'll get better at it. But for now, if you hear things like title and USC, you know you're dealing with a federal statute. They're printed, unfortunately, in order. So unless you're like Rain Man, maybe you don't even know who Rain Man is, but unless you have that unbelievable memory that, I'm looking for a law and I know it was passed in 1987 under this, session of Congress. Although they're printed in chronological order, people at the federal government and Westlaw and other legal organizations have organized it so you can find it topically. So you look up the topic and it will guide you to the year and the current law in that area. So it's much more easy to find than knowing things that are passed chronologically. You don't have to worry about that too much. And then I talked about judicial review. There's a pretty good assignment. 3-1 talks about, all the things about eligibility to be a congressman and things like that. And let me see if I missed anything. Now, again, I do want to stress, even though it's not in this chapter, the Congress only has power to create law based upon their enumerated powers, and that's in Article 1, Section 8 of the United States Constitution. It has gotten much broader than that, I would argue, based upon the reasonable and necessary clause and just the fact that the federal government, in order to keep us somewhat functioning, their authority is much broader, I think, than the framers first mentioned. But they are not omnipotent. They can't create laws in every single area that they might want, even if it's in the best interest of the nation, if it's not embodied in the enumeration clause of the United States Constitution. And that's what the court reviews. The court doesn't review whether a law is wise, whether it's just, whether it's popular. They review it to determine whether or not it violates some mandate in the Constitution or whether it goes beyond the powers that are actually granted in the Constitution for the legislation to be passed. We talked a lot longer than I hoped, but I think that's the legislature in a nutshell. You should know who this is an online class, makes it a little difficult, but if we were together, everybody should know who your House of Representative member is. You should know him for the whole state, but you should certainly know mine. I live in Brimfield, Mass. Mine is Richard Neal out of Springfield, Mass. I grew up in Springfield, and actually, when I was a student at Springfield Technical Community College, Richard Neal was an instructor there. Later, and he was a city councilor, became mayor, and then Congress member. He's actually one of the most powerful men in the country because he's the chairperson of the Ways and Means Committee. Any law dealing with revenue and taxation has to go through the House Ways and Means Committee first. He has a lot of power. You should know who your U.S. senators are. Right now in Massachusetts, we have Ed Markey and we have Elizabeth Warren, our U.S. senators. You should know your state reps and your state senators because the federal law doesn't deal with everything that impacts us. In fact, you're probably more likely to be impacted by state law, I'd argue. Most of us would be. And you should know who your state reps and your state senators are. My state senator just changed because of some rechanging of the map. I believe I have Senator Fatman, who's out of Senator Fatman is out of Sutton, Massachusetts. I live in Brimfield, but the jurisdiction is pretty large. And my state rep is a guy by the name of Todd Small out of Warren, Massachusetts. I mean, I know I'm a nerd on this stuff and I like this stuff, but someday you might be upset about why laws are like that. Maybe you want to run for office. You don't think you do, but you might at some point. You should know who the different players are because these people are supposed to be working for you in your best interest. And if they don't hear from you, you'll be ignored. They do get busy. I know some of them. I think they're good people for the most part. But let's face it, the squeaky wheel gets the oil. But you need to know who to squeak to, and you should know who these different people are and who's running for different offices when it comes up. You pay for them. They shouldn't forget that, and nor should you. Otherwise, something a bit long. Be well. I'll put this up, and again, don't be afraid to reach out when any questions are concerned, because I don't cover everything in the chapter. I just try to hit what I think are the high points. Don't ever be afraid. I didn't talk about this, and I'm curious on that. Let's have a dialogue. Shoot me an email, give me a call, and I'd be glad to talk. Be well.